Good evening, I hope everyone's well today. Thank you for watching, as always, it is appreciated. We've got a bit of an issue, and that is David Lammy. His deciding that we don't need jury trials anymore. This is what we need to get into today with our midwit Justice Secretary in England and Wales. Let's have a look now. The change is expected to be formally announced by the government next week. Sky News previously reported the Ministry of Justice was set to remove the right to trial by jury for thousands of cases in a controversial measure that would mark a move away from the core pillar of criminal justice in England and Wales. A memo sent to from David Lammy to fellow ministers seen by the Times says there was no right to jury trials in the UK and that drastic actions were needed to cut the backlog of cases in the Crown Courts, nearing 80,000. A spokesperson for the government confirmed the changes are coming soon to deal with the backlog. A couple of things to say about this first of all. The backlog is manufactured. It's not real. There's certain things that are causing the backlog, such as foreign criminals flooding the country through mass migration that we have to deal with, and no infrastructure to keep pace with demand. So, just like anything else, they've not built any new courts, they've not built any new judge positions, and they've not built any new prisons. And so, rather than actually do something to fix that issue, they would rather take away my rights and your rights. There isn't an absolute right to a jury trial in the UK, but there is an expectation, which is what we're going to get into. It's confected. The government creates a problem, then they create a solution. The solution is always detrimental to you or me, to take away your rights. The right to a jury trial isn't absolute, but it is a principle, going all the way back to Magna Carta. It's misleading to say that there's no right to a jury trial in the UK. The United Kingdom does have a right to trial by jury, but it's not a universal right and there's never been one. What exists is a long-standing constitutional principle that certain categories of criminal cases, indictable and some out-of-the-way cases, are tried before a jury unless the defendant chooses otherwise. That's important, which is what I'm going to get to later in the video. Let's just have a look now. Chooses otherwise, or a court properly orders a judge-only trial in very limited circumstances, which they're going to be expanding. In England and Wales, separately in Scotland and Northern Ireland, maintain this structure through common law tradition, statutes including the Juries Act 1974 and the Criminal Justice Act 2003, and others. Constitutional conventions protecting jury trial is key to safeguard in serious criminal matters. So if a minister like David Lammy has claimed that the UK has no right to trial by a jury, this would be incorrect, and if asserted knowingly, which Lammy has done here, it's also misleading. That's a sackable offence for a government minister, isn't it? Let me get on to this. It's not absolute, but it is, and it dated back to Magna Carta. Let's just see now. There are important expectations that sometimes lead politicians to make overly broad statements. Most summary offences, i.e. minor assaults, motoring offences, are tried without a jury. Judge-only trials can be ordered in rare cases if it's real and present danger of jury tampering. That's under the Criminal Justice Act 2003. And civil jury trials are now extremely limited. Alright? So it's not absolute, but it is an expectation in the most serious cases. This is the issue. The eroding our rights, and where is the Crown? Where is the King? He's meant to be a guarantor of our rights in the United Kingdom. Where is he with all of this? Let's just see. Lammy went on to say, he wouldn't be surprised if my colleagues in the Ministry of Justice are looking at perhaps some radical ways that we could reduce the backlog. Deport the foreign criminals, close the borders, maintain the infrastructure. There are many, many things you can do without taking away our rights. McFadden said that the backlogs in the court system are getting too long and showing no sign of shortening it or close the borders. He is referenced as saying that justice delayed is justice denied, implying that that non-jury trial is better than no trial at all. Let me go on here. Let's have a look now. In the summer A retired Court of Appeal judge, Sir Brian Levinson, made recommendations to the government, including the suggestion to end jury trials for many serious offences, saying they could be dealt with by a judge alone or a judge with two magistrates. This would have been done creating a new intermediate court called the Crown Court Bench Division, sitting between the magistrates and the Crown Courts. The plans, which were leaked in the document, go further, with suggestions saying that offences that could receive a sentence of up to 5 years would be headed by judges alone. This is the issue with abolishing trial by jury. It goes against Magna Carta. It goes against the doctrine that no free man shall be seized or imprisoned or stripped of his rights or possessions or outlawed or exiled, except by the lawful judgment of his peers or by the law of the land. What this principle means is that a lawful judgment of his peers is origin of the concept that people should be judged of others of equal standing. This is the principle here. Alright? Remember last year when we had Jamie Michael, the Royal Marine from Wales, and we had Lucy Connolly, both who were arrested and charged with a similar or comparable crime. One had the jury trial and was acquitted within 17 minutes. One didn't have a jury trial, was advised by their state-provided legal counsel to plead guilty, and they were sent down. Now, under the criteria that's being set out here, that any not suitably serious offence with a maximum prison sentence of 5 years would not go to a jury. So Jamie Michael would have been sent down, just like Lucy Connolly got sent down. There would have been no differentiation there, and a jury of his peers wouldn't have acquitted him because there would have been no jury to do that. This is dangerous, and the fact that this isn't being reported in the press is also dangerous. The state wants more power. It's all about control, and it's all about stripping you of your rights and your freedoms and your right to be held accountable by a jury of your peers, and not the Crown and not the state. That's all this is about. So we'll continue now. Mr. Bryan suggested that a judge and two magistrates could hear cases with maximum sentences of 3 years, but they said it could go as much as 5 years. These measures would be highly controversial, with the leader of the Conservatives, Kim Badenoch, saying it risks fairness, undermines public trust, and erodes the very foundation of our justice system. The Criminal Bar Association said it would eviscerate the jury trial as we know it. I don't agree with any of this. I think it's shocking that isn't going to play in the media. Let's have a look now. In 2005, by the way, there was a change to the way that the judges were appointed with the move away from the law lords. The key change was the creation of a JAC, which is the Judicial Appointments Commission. As I say, this was done in the Blair years. Before 2006, the senior judges were effectively appointed by the Lord Chancellor, a political figure. After the secretive consultations, Labour reforms aimed to make the system more transparent and less political, when they achieved the opposite. Under the 2005 Act, an independent Judicial Appointments Commission was created. It is responsible for electing candidates for judicial office on merit through open competition. The Lord Chancellor's role was reduced and limited to one. They can accept or reject or ask the GAC to reconsider a recommendation, but they can no longer choose candidates themselves. A lot of people in the legal profession think it has become too political, because what you can do is you can filter out people who have wrongthink, who are not part of the Blairite regime, and they just don't get the opportunities because they're saying the wrong things. This is what is also been lost with the amendments to the justice system that were made under the last Labour government. Goes on here, alright? It is politicisation by process. Judges now go through something called a civil service, resembling a civil service style appointment system. The GAC uses competency frameworks, written applications, interviews, and diversity targets, soft quotas, not strict quotas, that pressures to diversity. It brings judicial appointments closer to public sector political priorities, i.e. diversity, equity, inclusion, representation and managerialism. It risks selecting judges who excel at applications and interviews rather than the traditional indicators of the judicial aptitude. it embeds government policy in the policy preferences for the criteria. So if you're not a blur-eyed judge, you're not getting in. They want to abolish juries because I think they looked at what happened at Southport last year and think, hang on, Keir Starmer, former Director of Public Prosecutions, has directed his judges to convict these people. The state had already declared all of these people guilty, which is why they got severe sentences when they pleaded guilty, because the state wanted that. Because certain people opted for trial by jury, that is a affront to everything that Keir Starmer stands for. He said you're guilty, the state has said you're guilty, how dare you defy us and ask for a jury? And that's what this whole thing is about, in my view. Now, as always, your mileage may vary. You may think I'm overstating things or I've got it just right. Consider liking, subscribing, and I'll see you in the next video. This needs to be repealed. When Farage gets in, this needs to be repealed. This is just another thing that needs to go. Like, comment, and subscribe, and I'll see you in the next one.